Hello, good afternoon, and welcome to this webinar from 42BR Barristers. My name is Iris Ferber Casey.
I'm Stefan Liberadzki.
And we are both employment law specialists at 42BR. And this is the first webinar in our 2025 employment law series. We're going to be running this series of webinars until April, and I'm sure there will be more webinars after that too. A few bits of housekeeping. If you've got any questions while we're chatting, please do put them in the Q&A box. If you put them in the chat, we will not see them. So put them in the Q&A box. We will then look at the Q&A box at the end of the session, and we will answer time permitting your questions at that point. If we don't have time, or if we miss anything that you've asked, we can respond to questions by email afterwards. So please do let us know by email if you want to ask us any further questions. You're going to get an email containing this recording and a feedback form in the next few days after this webinar. Please do fill in the form. And please note that the recording is also going to be available on our website and the YouTube channel in the next few days after this session. So there we are. I think that's housekeeping done, isn't it?
Yep.
Should we get started? Stefan, we're talking about Section 19, capital A.
We are.
Of the Equality Act 2010. Tell me a bit about it.
Well, it's probably best start with the original Section 19, which is still in force. Which is still in force, hasn't gone away.
Yeah.
That's the indirect discrimination provision. If you're watching this on a computer, it might be worth just bringing up Section 19 on the Gov legislation website, because I'm just going to compare the wording of Section 19 and the new Section 19 so we can see how it's different. So, of course, what Section 19 has for indirect discrimination is where the discriminator applies a provision, criterion or practice.
Let's call it PCP.
Let's call it PCP. It's much quicker. Yeah. And they apply it to both people who do have a certain protected characteristic and people who don't have the protected characteristic. So they apply it neutrally to everybody.
So that's the first bit.
That's the first bit, PCP applied across the board. The second bit is what we call group disadvantage. So it puts or would put persons with a particular characteristic at a particular disadvantage when compared with persons who don't have it. And then the individual bit, it puts the claimant, that's B in the language of the legislation, at that disadvantage. And then the last bit is the discriminator A has to justify it as a proportionate means of achieving a legitimate aim.
And just quickly going back to the beginning of that, the very first bit about the PCP uses the words PCP, which is discriminatory in relation to a relevant protected characteristic of B.
Yes.
So it links the protected characteristic, the two groups, let's say men and women, and let's say women are the disadvantaged group. The claimant has to also be a woman in order for Section 19 to kick in.
Exactly. It's there in black and white in the language of the legislation. Section 19A says something a bit different for the individual at least, but it's worth noting that the first bit, this applying the PCP across the board to both groups, is still there. It's still the same. And there is still the same requirement to show that it puts people of a particular the group with particular protected characteristics, so women in your example, at a disadvantage. But then when it comes to your individual, B, the individual, it says B does not share that relevant protected characteristic. So in that case, B is a man, and the PCP puts or would put B at substantively the same disadvantage as persons who do have the protected characteristics. So in this case, puts a man at substantively the same disadvantage as it would for women as a group.
And then we have the justification.
And then there's a justification. So it's titled indirect discrimination, same disadvantage. And it's this wording about B, the individual, not having the protected characteristic of the group that is disadvantaged.
So to summarise that, Stefan, although Section 19 and Section 19A are not structured when you look at them on the page absolutely identically, that they are different. The wording is slightly different here and there. Essentially, the only difference between the two sets of questions in section 19 and section 19A, I think, is that in section 19, the claimant, person B, has to have the same protected characteristic as the disadvantaged group.
Yeah.
And in section 19A, the claimant, person B, must not have the same protected characteristic as the disadvantaged group.
Yeah.
That is the difference.
But
and we're sort of, I'm hedging this by saying I think that's what it means, because something that's worth saying up front at the start of this webinar, we don't have any cases directly about this law yet.
Yeah.
So we are talking in theory a little bit, though we're going to talk about the history of the provision in a minute, and that will help us to discuss the issues.
Yeah, we'll look at the history of where this came from and why it's there. But you're right, with section 19A, B, the individual, although they have to not have the protected characteristic, they still have to be put at the same or substantively the same disadvantage as the wording in legislation, as the group who is disadvantaged. And we'll come on later to discuss what does substantively mean here.
Right.
How must it be applied?
In section 19, the sort of classic indirect discrimination section, the one we're all used to, let's use again the examples of men and women. I'm a woman who suffers a particular disadvantage as a result of a policy. As long as I can show that women generally, as a group, face that disadvantage, and I also face that disadvantage, then I, subject to all the other elements of the case, I win my claim. In some ways, that's conceptually very straightforward, because I'm a woman, the group is a group of women, I'm part of the group. Yeah. So there's no reason for the disadvantage issue to be complicated. Although you do get cases, don't you? It's just as a bit of an aside, you do get cases that are lost under section 19, where the claimant, it turns out that the disadvantage to the particular claimant is actually not the same as the disadvantage to women.
Well, they can't prove on the evidence that they've in themselves suffered that disadvantage.
Well, they can't prove that they've suffered any disadvantage at all, absolutely. But you certainly do get cases where somebody's particular disadvantage is actually to do with something completely different or of a completely different nature than the group disadvantage. And then those claimants lose their cases. But that is rare. Most of the time, because they share the same protected characteristic as the group, generally it's relatively straightforward. Whereas with section 19A, because by definition, the person in our example is a man and not a woman, there is a real focus on the disadvantage and the comparison of the disadvantage. Indeed, the title of section 19A is indirect discrimination, same disadvantage.
So I would be saying, if I was making a claim as a man, I'd say my employer's policy, look, this is how it disadvantages women as a group. I can prove this with, statistical evidence or whatever evidence you need. Although I'm not a woman, I have suffered that same disadvantage. So let's say it's inflexible shift patterns that make life difficult for people who have childcare responsibilities, who are predominantly women. So the group disadvantage is there to women, but I, an individual man, I have childcare responsibilities and I've suffered the same disadvantage.
Right. Yeah. So that's a good example, because the facts, other than the fact you are a man, actually, if you are a primary if you have primary childcare responsibility for young children, there really isn't any reason to differentiate your disadvantage from the disadvantage to a woman with primary childcare responsibilities. Okay, so that's kind of the broad chat about what section 19A looks like. And in a way, we could stop there because we don't have any case law. That's what the section says, and that's all we've got. But that would be a very short webinar, only 10 minutes in. So let's do a bit more than that. Let's talk about the history a bit. We tend to avoid sort of overly academic conversations in these webinars, and we're not going to make this an academic conversation, but it is actually quite important to understand where section 19A comes from, isn't it, I think?
Yeah, so we need to look at the history behind why it's been enacted, and it comes from EU law, and in particular a decision that the European Court made in 2015 that was called Ches. And
Ches was the name. It's a Bulgarian case, and Ches is the first bit of a very long name of an electricity company. So Ches is the electricity company. Tell us the facts, because the facts are interesting.
They are. So this electricity company, they looked at an area a geographical area, and they put all of the electricity meters high up out of reach.
Like 7 meters.
7 meters high, yeah, on the pylon. So people could no longer actually read their electricity meters, and as a result, they were claiming they were being overcharged for electricity.
And that was everybody in that district.
Everyone in that area.
Everybody's meters were up.
But the allegation made against the Ches utility company was that they had targeted this area because of the Roma population there, and because of essentially a prejudicial view that Roma people were stealing electricity. But the claimant in that case wasn't a Roma individual. They lived in that area, but they weren't Roma.
She ran a shop.
That's
she
right.
Was definitely not. I mean, there was no suggestion that she was Roma.
Yeah.
But because she lived in the area in which this adjustment had been undertaken of raising these meters, she, in her shop for her business, could not read her electricity meter.
And it's interesting because on the face of it, that actually sounds like a direct discrimination complaint, because the utility companies deliberately targeted this area because of its Roma population.
Yeah.
So that's not a neutral practice. That's a targeted.
Yeah, that's right. That's not everywhere in Bulgaria that we install meters, we're putting them at 7 meters high.
Yeah.
We are choosing to put these meters at a particular height because of race, directly because of the race of the predominant racial group in the area. So tell me, Stefan, is this not simply a direct race discrimination case with no relevance to indirect discrimination at all?
Arguably, it was just direct, but the European Court's judgment seems to go wider than that, because in their judgment, they refer expressly both to less favourable treatment, which is a direct discrimination concept, and particular disadvantage, which is an indirect discrimination concept.
And that's been picked up, hasn't it? And focused on in lots of cases. That the phrase particular disadvantage was expressly chosen to be used by the ECJ.
And they said that the Race Equality Directive was intended to benefit people who aren't members of the particular racial group that's been disadvantaged, as long as they suffer the same disadvantage as that racial group does. In essence, they're saying that for European discrimination law, it's enough to have a PCP which differentially disadvantages one protected group.
So one race
compared to another. And if that's can't be justified, then it is unlawful, and that's the end of it. And it doesn't really matter whether the identity of the individual claimant who's bringing the claim falls within that racial group or not.
Okay, so the claimant in Ches, the shop owner, could have been Roma. She could have not been Roma, irrelevant.
Yeah.
The fact is that there was a policy in place that Ches, the electricity company, had put in, which was affecting Roma people differentially from non-Roma people, because the meters were installed so high only in the Roma areas.
Correct.
That's enough for it to be an unlawful policy.
Yeah. So, Iris, what impact did that decision have in domestic law?
Well, let's rewind a bit. We've got associative discrimination. So we tend to refer to discrimination against people who don't themselves have the protected characteristic as associative discrimination. But we'll come on to this. It's perhaps not the best word to use to describe this type of claim. Nevertheless, it has been used historically, so let's stick with it for the moment. There's a case from before the Equality Act was enacted, of Coleman and Attridge law, which made its way, I think, all the way to the ECJ itself, which was to establish and clarify that the pre-Equality Act discrimination statutes allowed for a person to be directly discriminated against, so treated less favourably by reason of, directly because of a protected characteristic, even if that protected characteristic was not their own protected characteristic. If it was, say, somebody that they cared for, like a disabled child, and in Coleman it was in fact a disabled child that was the person with a protected characteristic that led to the successful claim. So there was this extension of direct discrimination to associative discrimination. And then when the Equality Act was enacted in 2010, Section 13 of the Equality Act, which of course describes direct discrimination, specifically didn't link the less favourable treatment to a protected characteristic of B, person B, which is the way that the Equality Act describes
it's just less favourable treatment.
It's just less favourable treatment because of a protected characteristic.
And
it's worth saying that when you're reading ththese cases, including Coleman and the other cases that are pre-2010, that the law on both direct and indirect discrimination and the elements of associative discrimination that you could perhaps find in the wording of the Act was quite different before the Equality Act. I know there was lots of commentary when the Equality Act was enacted about it not changing the law, but simply rationalising and standardising the language across all the different acts that previously existed, separate acts for different protected characteristics. In the field of indirect discrimination, there had been a particularly wide range of different sorts of wording to describe indirect discrimination. So once the Equality Act came in, we had one definition in Section 19A and...
Section 19.
Sorry, thank you. Section 19, quite right.
Yeah.
And from 2010 until last year, that was the only section that described indirect discrimination.
But there were attempts to get around this requirement to have for the individual to have a characteristic.
Interpret the legislation purposefully.
There's one example, just touching on briefly, it was called Hainsworth.
That's from a while ago, isn't it?
2014. So it was before the Ches decision. And this was actually a reasonable adjustments claim. And reasonable adjustments is the same as indirect discrimination in that the individual claimant has to have the disability.
And there's a PCP that has to...
Exactly, and it puts them at a disadvantage in comparison with non-disabled people. But in Hainsworth, the claimant tried to argue that European law required the reasonable adjustments provisions to be read in a way that effectively meant that the claimant doesn't need themselves to have a disability, and that it's enough that they're put at the same disadvantage as a disabled person who they're connected with. And
so that's a kind of reasonable adjustments version of what we're talking about in relation to indirect discrimination.
So in that case...
How did that go?
The claimant lost that in the Court of Appeal. So the claimant was a mother of a disabled child. The employer changed her workplace, and she argued that meant the change of workplace meant she can no longer meet her child's special needs. And she suffered a disadvantage connected to that. But she said the EU's Equal Treatment Directive for disabled workers required the Equality Act to be read in a broader way. And the Court of Appeal said, no, that's not actually what the EU Equal Treatment Directive says. It only covers adjustments for disabled workers themselves.
So I mean, that comes back to, keeping with the sort of history lesson here and bearing in mind that we're not going to labour this point because the law has now changed. We've left the European Union and these principles no longer apply to our law. But for context, let's bear in mind that the Marleasing principle from the Marleasing case, up until December 2023 in our law, said that when an act of parliament derives from an EU directive, derives from EU law, one looks at the purpose behind the EU law and interprets the domestic legislation so as to give effect to that purpose. And that can be really a very flexible concept indeed. And the Hainsworth case is interesting because the Court of Appeal didn't say we refuse to apply the Marleasing principle. They couldn't have said that. That's the law. They had to apply the Marleasing principle. They were actually saying we're applying the Marleasing principle. We are looking at what the EU law says, and the EU law on what they call reasonable accommodations, what we call reasonable adjustments, is limited. The EU law itself is limited to making adjustments for disabled people, not for those associated
with. Which is different to how, as we've seen, the Court of Justice in Ches then interpreted the Equal Treatment Directive. In that case, it was about the Race Equal Treatment Directive, which is the broader concept of direct and indirect discrimination.
Yes, rather than reasonable adjustments.
For disabled people,
The focus on direct and indirect in Ches was to say these directives do allow, in fact, require national law to give effect to to laws against discrimination, both direct and indirect, whether or not the individual themselves who's making the claim has the protected characteristic.
Yeah. So, Iris, there were following chairs, I think, a couple of employment tribunal decisions that implemented it or said they were implementing it at first instance.
Right.
Tell us about those.
They both happen, I think, probably coincidentally, to have taken place in 2020.
Yeah.
They both relate to, inevitably, because we're talking about employment tribunal litigation, which is very slow, they both relate to pre-pandemic cases. So they heard, firstly, a case of Groves in June of 2020, and then a case of Follows, a nationwide building society, in December of 2020. Both of them review in quite a bit of detail that European case law, including chairs, the Marleasing principle, and so on, in relation to whether it is possible in the UK employment tribunal to run what they both call an associative indirect discrimination claim. The Groves case, which is a Scottish case, is actually quite a nice read if you are interested in the history of this topic, because this is historic, but it informs why Section 19 was enacted as it was, 19A was enacted as it was. So if you are interested, Groves is a nice case to read. It's available on the ET Judgments database. And it's a Scottish case, and it's nice because it's a pure preliminary hearing only on the legal question of whether Section 19, as it was, allows for associative indirect discrimination. We don't know anything about the facts of that case, other than that the claimant in that case had, I think, a disabled husband. I think it was. So we were talking there about the classic associative discrimination type of claim, i.e., I am not disabled, but a member of my family is. And that I have a direct connection with somebody who has.
But in the context of indirect discrimination.
But in the context of indirect rather than direct, the parties had made very detailed written submissions, which the judge very handily pretty much recites wholesale in the judgments. You get to read almost the skeleton arguments of both parties in Groves. And then you get a fairly detailed discussion from the tribunal judge back and forth about the points made by claimant and respondent, and ultimately coming down on the side of, well, in Ches, the European Court of Justice was really clear that this is how the law of indirect discrimination should be read in light of the directives, and that is how it must be read. There is then a second case, as I say, from December called Follows in Nationwide Building Society, which is a much longer judgment because it's a full trial dealing with a lot of different issues, including indirect discrimination. That again sets out the law in quite a lot of detail, chairs Marleasing, etc. But then the bit where the tribunal applies the law to the fact is actually pretty short, and they sort of say, we're going to follow chairs. And we're going to say that associative discrimination is a valid claim, and the respondent hasn't really answered that claim because it was basically saying you can't run it and didn't really raise any other issues, and therefore in about 3 paragraphs in the judgment, the tribunal decides that the associative indirect discrimination claim is a good claim.
And it was upheld,
Exactly.
And because in that case, the respondent had made this claimant redundant because they wanted all their workers who previously worked at home to now come into the office, although this was pre-COVID. And this claimant couldn't because she cared for her disabled mother. And
so again, an associative.
It's association, but the respondent didn't really put in the evidence about why they needed this change of practice and why it was justified. So that they, like you say, once they'd lost on the legal argument, they sort of lost on
nowhere
the
else to go
as well.
Absolutely.
Okay, so we had those 2 cases, and we might come back to that later when we look at would those cases still work as claims under the new Section 19A. But let's look at one more which arose. It's called Rollet against British Airways, and this is the only one of the domestic cases that actually went to appeal to the AT. And
it's the only case so far that directly deals with Section 19A.
It sort of does, but it's a little
It's never
complicated.
that simple.
It's a bit complicated. So
Yeah.
the facts of Rollet arose during what we call the transition period. So you might remember the UK officially left the EU at the end of December 2020, but there was this 3-year transition period up to the end of 2023, during which courts still had to apply European law principles to domestic legislation. And the facts in Rollet arose and the claims arose during that transition period. So by the time it got to the EAT in 2024, although the transition period had ended, the EAT still had to apply the law as it had been during the transition. So in other words, still apply EU law. But Section 19A then, as I say, was enforced by then, but it didn't, strictly speaking, apply to these facts, although what complicated it is that the Minister for Women and Equalities did intervene in the appeal because they were interested in basically arguing that Section 19A was lawfully enacted and wouldn't be in some way have doubt cast on it by the EAT. So
and I think they wanted to establish that the principles in Ches don't want to
did justify.
The principles in Ches were what, you know, to establish what those principles were in a proper EAT decision, and then for the EAT to say, oh, and Section 19A does exactly the same thing.
Yeah.
They wanted that consistency established in the case law.
Yeah. So Iris, tell us about the facts of Rollet.
Okay, so it's Rollet and British Airways.
Yeah.
So everybody remembers, I am sure, the absolute catastrophe for the airline industry of the initial lockdown in 2020, a complete shutdown of all airlines, inability to travel, and really there was no ability to trade at all for several months for the airline industry. And when that began to be relaxed later in 2020, British Airways, like many other airlines, felt it had to take drastic action in order to stay viable as a business. And two things which British Airways did in 2020, the period of time that the Rollet claim is about, which is because the claim was issued in January 21, so we're really talking about steps taken by British Airways in 2020, was to reschedule staff arrangements completely. Yeah. So to completely change shift patterns and how they
a lot more short notice,
much more short notice.
Shift.
And precisely, and to change the shift patterns and to make such patterns as they were imposing on staff much more flexible. And of course, when a respondent says flexible, what they mean is flexible for them.
So come in when we want you to come in.
You come in when we want you to come in. And British Airways was saying, unless we have this flexibility, we're going to collapse as a business. We have to be able to have this flexibility in order for the business to survive. So it was a sort of existential argument about whether the airline industry could do make these sorts of changes. And the claim was by cabin crews, a group claims, Rollet was just the lead claimant.
And what were the protected characteristics of these cabin crew?
So there were two groups.
Yeah.
There was a race group and a sex group. Obviously, the sex group was men versus women. Come back to that. That's relatively straightforward to describe. The race group was British nationals versus non-British nationals. And the way the claim was put was that the flexibility, i.e. short notice changes to shifts that were imposed on cabin crew meant that as a group, non-British nationals that work for British Airways, of whom there are many, who are travelling to the hub at Heathrow from abroad.
Which they're more likely to do because they're more likely to live abroad than British nationals.
Right. The changes to shifts significantly disadvantage the people who live abroad.
They have to make these long journeys.
They have to make much longer journeys at short notice to Heathrow, and that as a group, non-British nationals are much more likely to have those disadvantages because there are a lot more of the non-British nationals are living abroad. So you've got the disadvantage being having to travel from a further distance away from abroad into Heathrow. We've got a group which is the non-British nationals group, and we've got a lot more people in the non-British nationals group being affected by that disadvantage than people in the British nationals group. So that's that group.
Yeah.
For women, straightforwardly, and we've touched on it a number of times, it's a very common type of indirect discrimination claim. Women with primary childcare responsibilities were, generally speaking, going to struggle much more than men who predominantly don't have primary childcare responsibilities, again, with the flexibility, with the very short notice requirement to travel to Heathrow to take up
find childcare.
Having to find childcare at short notice.
Yeah.
So those are the two groups which are the first bit.
So the ordinary Section 19 indirect discrimination claims, but
yes,
then you have the CHES type indirect discrimination claims of people who weren't in those protected groups, individual claims who weren't in those protected groups.
So Rollet, as you would expect, also is a claim about women being disadvantaged, and a lot of the claimants were women in the Rollet case, and they were not saying, oh, this is an associative or same disadvantage claim. They were straightforwardly saying, women are disadvantaged by these flexible policies. I am a woman. I am disadvantaged by these policies. Straightforward Section 19 claim. I have childcare responsibilities. Women as a group have more childcare responsibilities. And equally, lots of non-British national employees of British Airways saying, I am a non-British national. I am struggling to get to Heathrow on time. As a group, that is a disadvantage which applies, and it applies to me personally.
Individually,
That's all there. But rather sort of Alice in Wonderland-like, the same individuals that formed the other group in those 19, the comparison group in those Section 19 claims. So men, for example, in the sex discrimination, the sex indirect discrimination claim, some of those same men who form the group, who are as a group the less disadvantaged, in fact also had the disadvantage. So in our example, men with primary childcare responsibilities. And those individuals, and the EAT judgment names one of the individuals, to give a really straightforward example of this, was a man with primary childcare responsibilities who suffered the identical disadvantage that any woman with primary childcare responsibilities would suffer from having to get to Heathrow at short notice and make childcare arrangements. And the EAT also gave the example of a British national living in Chamonix,
in France,
who was having to travel to Heathrow at short notice. And again, just like a non-British national living abroad, that was a disadvantage to her.
So if we look then at the legal issues that arose because of these special claims, but by the British nationals and the men. The parties, the claimant and respondent, actually agreed in Rollet that the CHES case, as a matter of EU law, meant that there was an ability to make a indirect discrimination claim based on this same disadvantage principle, even though the claimant isn't a member of the disadvantaged group. So there wasn't actually a dispute that CHES required this.
CHES itself wasn't a part of the argument.
They weren't.
Everybody accepted what it said, even though we looked a bit at the history. You could say, well, CHES is actually really a direct discrimination claim. Are the dicta of the ECJ really determinative statements of the law? But that didn't arise.
The respondent didn't try to run that argument. CHES was confined really to direct discrimination. They accepted it and applied to this indirect discrimination.
So tell us what
it actually all came down to was whether we talked about this leasing principle and reading domestic legislation the way that's compatible with EU law. It was all about whether the leasing principle required tribunals to read Section 19 in a way that means that actually the individual claimant doesn't need to have the protected characteristic, even though Section 19 expressly says they do need to have it. And the question is, did that go too far in reading words into Section 19 that aren't there? And does it go against? Would that go against the grain of the legislation and the thrust of the Equality Act? And the EAT said, no, it doesn't go too far, and tribunals can and actually have to do this. They have to read Section 19 compatibly with EU law. And that was what Mr. Justice Easy decided.
Okay, so
Yeah.
but that was in Rollet was in 2024.
Yeah,
I think about halfway through 2024 it was
but
published.
in the meantime,
Section 19A had been enacted.
Yeah.
So in a fresh case, if you're, I mean, I suppose as things are now, because of the 3-month plus a bit time limit on tribunal claims, all of the cases you're going to see coming across your desks are going to be post 1st of January 2024 situations. But let's for a moment step back and imagine that you have circumstances where the issues arose before the 1st of January 2024. As we get further and further away from that, that's less and less likely, but let's for completeness discuss that. If you've got a situation where the disadvantage to the claimant arose before 1st of January 2024, arguably you're applying Rollet to Section 19 for that case. And the point that that the President of the EAT, Mr. Justice Eady, made, and the point that the intervener, the Minister for Women and Equalities, was keen to point out, is that the way that the EAT was interpreting Section 19 is now identical to, or should be identically viewed as, the new Section 19A. It's just the same law in Section 19 and in what is now Section 19A. And if your facts are post 1st of January 2024, you just go to Section 19A and use that.
And they expressly said that the reason that Section 19A has been put in there is once that transition period ended, then all of that Ches principle would have just fallen away unless there was a domestic legislation provision to preserve it. And
so government made a specific point about that.
And the Withdrawal Act gave the government power to basically preserve old EU law principles, including by amending primary legislation. So Section 19A wasn't actually enacted by Parliament like primary legislation. It came from regulations that inserted it using that power. And the explanatory notes, if you read the regulations that
as we have been preparing for this webinar,
say expressly it's to codify that same disadvantage principle. And it's titled Section 19A, Indirect Discrimination, Same Disadvantage. Right. So as we went through earlier at the beginning of this, you still have to have a PCP. It still has to apply to both groups. With and without the protected characteristic. It still has to produce a disadvantage to one of the groups, a particular disadvantage. But then the difference with Section 19A is then the claimant, the individual, is not a member of that group. But
it positively cannot be a member of the group in order for Section 19A to apply.
And they must suffer substantively the same disadvantage. Substantively, does that mean anything special, Iris?
Well, is it a trick question? Is it Section 212 definition section of the Equality Act? Substantial means more than minor or trivial?
No.
Easy peasy, it's all there in the Act. No.
A very subtle difference, substantial and substantively. Now,
you think those are two different things? I think I probably tend to agree with you.
They might be. I think what it's getting at is it's saying that the core, the essence of the problem that the person has needs to be fundamentally the same as the problem that the group faces, even if there's some differences around the edges in their exact individual situation. But the legislation doesn't define it expressly, but I think that's what it's getting at.
I suppose if you take away the adverb ending, the word substantive means in substance.
Yeah, in substance.
So in substance, if the disadvantage is the same, then there should be a good, if everything else can be proved, the person should have a good claim. And we're going to talk in a moment. We're going to come on to some sort of applying this to some facts so that we can sort of illustrate how this might work. But let's step back for a moment. There's a lot of commentary about Section 19A saying this is crazy. You know, a same disadvantage, indirect discrimination is so broad that it's not really a discrimination legislation anymore. What's it really doing?
The point's made that basically anyone could take any rule at work, or not just work actually, but all the areas of the Equality Act covers.
Yeah, premises, services.
And say this policy is unfair in some way.
Yeah.
It puts some people at disadvantage. It's also put me at a disadvantage, even though I'm not a member of that group. So people are saying, it massively broadens the scope of the Equality Act.
Now, and then there's the question, so that leads on to the question, would it have been better to stick with associative discrimination, indirect discrimination, which was what was discussed actually in our Follows case and our Groves case, the two first instance decisions from 2020 that we've had a chat about, where the individual has a person that they are associated with personally, who has the protected characteristic. Stepping back from this, it seems to me, actually, that's a rather difficult, the associative discrimination is almost a more difficult type of claim to envisage. Take, for example, sex discrimination. Is there any claimant that you can think of, man or woman, who isn't associated with somebody of the opposite sex? Exactly. You know, it's a pretty meaningless thing. It often works with disability, doesn't it? Disability claims, because people often in disability claims say, well, it's my son or it's my parent or it's my spouse who has the disability. And there's a straightforward associative element there. But, you know, easy cases sometimes make bad law. You know, if you step back from it and think about what the law should say more generally about indirect discrimination, actually using association, personal association is actually quite a difficult way to construct an indirect discrimination law. The advantage, maybe I won't use the word advantage, the good thing about same disadvantage, though it's problematic, is the way that the ECJ describes it in Chairs. I'm not saying anything about personally whether I think it's a good or a bad idea to have such a definitely wide definition of indirect discrimination, but I do think that there is a logic to saying this policy differentially affects different protected groups, groups with different protected characteristics. The whole structure of our equality law depends on assessing protected characteristics and how they are disadvantaged. Therefore, so long as a policy does differentially disadvantage one group with protected characteristic versus another group without the protected characteristic, and it's not justified, why shouldn't there be a claim in the hands of anybody any person who is themselves affected by that disadvantage? So then I think we're going to end up coming down to, and this is where I think it's worthwhile in the last 10 minutes or so of this chat to talk about specific examples and see how this might play out. This is where it's right, I think, that in the end, the real cases in the real world, when they come along, will focus on substantively the same disadvantage. And how is that test going to play out in practice?
We thought of some examples.
We thought that might be useful, rather than talking totally hypothetically. Okay. So let me start then with some examples. Let's use Rollet, because we've talked about it and we know what Rollet was about. It was about an airline applying very flexible, that is very short notice changes to shift patterns. And so we talked about a race discrimination claim, indirect race discrimination claim, two groups, British nationals and non-British nationals. The non-British nationals group, in general terms, are more disadvantaged than the British nationals group, because they generally, as a group, have further to travel to get to Heathrow at short notice to carry out their shifts.
So that group disadvantage bit is made out, which is the same under Section 19A as it is under Section 19.
Right. So then how does the substantively the same disadvantage, Stefan, do you think, play out in a claim like that? If I'm making that claim and I am not a non-British national.
You are a British national, but you also live abroad and you have the same problem as non-British nationals who are having to travel to work. Well, the employer, the airline might, in that case, they might start nitpicking, and they might say, well, it's not exactly the same disadvantage for you because, for example, you don't have to get a visa and go through immigration checks because you have a British passport. You can just effectively walk straight in.
Is that nitpicking? I mean, that sounds like a significant difference to me, doesn't it? I mean, it's okay, yeah. In substance, a different sort of disadvantage. Why can't that be a good defence?
Well, the claimant would say that the disadvantage isn't about getting through immigration. They'd say it's about the travel itself, which is the same whatever nationality you are.
So I think what we're getting at here really is, like many other types of technical discrimination claim that we see pleaded in the employment tribunal. I'm thinking now of reasonable adjustments claims, but it applies to lots of different claims. The way that the claimant presents their case, what we traditionally call the pleadings, the way the claim is actually described, the wording used to describe the PCP, to describe the disadvantage, is really important. The claimant has to think really carefully when they are presenting their Section 19A, their new Section 19A claim, to describe the disadvantage in the right way so that it is substantively the same.
And the respondent
as what they
can't go back and sort of pick out ways in which they can say, actually, no, it's different in ways X, Y, and Z for you compared to the people who are in the protected group.
Well, do you think then, Stefan, I'm not saying there's actually a good answer to this one way or the other, but do you think it's valid for British Airways in the case like this to say, no, you've pleaded a disadvantage and you say it's the same, but actually when you look factually at the disadvantage, it isn't the same. That's
a valid argument for them to say. And then if they point to, like I said, not having the difficulty of passport control and visas, and they can say that overall the disadvantage is not substantively the same. It's basically not as bad for British nationals as it is for non-British nationals. And then it's for the ET to just put their finger in the air and say, what does substantive mean and how different or similar does it have to be?
Yeah, and there has to be a line drawn by somebody, doesn't there? Because there must be all sorts of personal disadvantages that are personal to the person, to the claimant. There are some really wide disadvantages that will apply to everybody. And then there's a sort of grey area in between of things that do apply to some people in the group and don't apply to some. So it's really interesting. And although, as we said right at the beginning, in principle, in an ordinary Section 19 claim where you have a non-British national applying and the group is also non-British nationals, there still is that question of whether it's the same disadvantage. You still have to prove that, but it's often just not something that is focused on particularly because it's straightforwardly the case that it's the same disadvantage. With the Section 19A claims, that's going to be the focus.
Where by definition the claimant is not in the protected group.
So then the disadvantage is the thing that everybody is focusing on. So shall we give the other example from Rollet and just see if that gives us another useful illustration of how this might work? So we've got the case of a man with childcare responsibilities, as it happened in Rollet. Many of us know cases where this comes up factually and has done before the law was changed on the 1st of January 2024 and then confirmed by Judge Eadie to have actually been like that before 1st of January 2024, that we all have these cases where there is a man who is disadvantaged by the ways of working at work by their own individual primary childcare responsibilities. But in the past, those men have not brought in direct discrimination claims because they are men rather than women.
And as a side note, it depends on the facts, but quite often those men could potentially bring a direct discrimination claim if they can show that, for example, their female colleagues with children were given a certain level of flexibility that he himself was not given. And I've dealt with a couple of cases where that's been part of the argument, and something you can potentially plead both. You can say, well, either I was me being singled out as a man and not being given flexibility, but even if I wasn't, there was a PCP that treated everyone the same, and I'm bringing a Section 19A claim. So it's worth saying you may not always need to rely on Section 19A. It depends on the facts and the reason why the employer treated you the way they did.
But you should certainly, if you're claiming and you're constructing your claim, you should look at the facts very carefully and think about whether the facts might also give rise, or alternatively give rise, to a direct discrimination claim.
Yeah.
If you're finding yourself saying, actually, a woman would have got wouldn't have had this policy applied to her so strictly as it's being applied to my client, then you're probably in the territory of a direct discrimination claim. Not to say you don't want to also include a Section 19A claim, but just be aware that there might be other claims to raise as well. And again, just coming back to this vexed question of substantively the same disadvantage, can a claimant man in a case like this plead the disadvantage as it suits him to plead it, to make sure that he can put himself in a box that is the same or substantively the same disadvantage as women, or is that sort of improper or the wrong way of pleading?
Well, case? I think claimant lawyers will certainly have a go of it and will say that, let's say a strict, let's say an antisocial shift pattern with rotating night shifts. That puts women as a group at a disadvantage, and the particular disadvantage they focus on is not being able to arrange childcare.
Well, there's no reason why for a man with primary childcare that would be any different.
It's exactly the same.
It's going to be exactly that. On the facts, that's quite easy, isn't it?
Yeah.
Well, in some ways, although it's useful to use that example of childcare and men and women, partly because the disadvantage is the same, and factually it's pretty obvious. It's also useful, isn't it, I think, Stefan, to think about a case where that really might not be so obvious. So let's talk about disability, because those are claims where disadvantage can actually be rather complex and rather difficult to establish, or the type of disadvantage. So let's imagine a case in which you have an employee with, let's say, a back injury, but one which has not lasted for longer, or did not, let's keep it simple, a back injury which resolved within 12 months. So it's definitely the case that that individual is not disabled, but they have had a condition which, if it had lasted for 12 months, would have been a disability. It just so happened that it resolved within 12 months, and therefore they're not disabled. But what about that person losing pay as a result of being absent from work during their back condition being active? And that person raising a Section 19A claim saying that the pay provisions, the sick pay provisions in that business disadvantage the group of disabled employees, employees disabled with back problems, more than those policies disadvantage the employee group without back problems. And that I, as an employee with less than 12 months back problems, have exactly the same disadvantage.
Yet I don't have a protected characteristic of that disability.
Hence, I'm under Section 19A rather than Section 19. Does that work, do you think?
I think it could work, because the claimant would say the disadvantage is simple, it's loss of pay, and it doesn't really matter for how long. It's of the same nature, or at least substantively the same, because that broadens it a bit.
So we think it does broaden it a bit. It has to. Same
it doesn't need to
and
be identical.
Substantively same can't be identical, can't be the same. There must be some broadening of the phrase same disadvantage.
It allows
adding
for
the
that
word substantively.
It allows for those differences around the margins, or a difference of time, in this case, of duration. But the respondent, they might say, well, by definition, a disabled person will have this condition for more than 12 months, so they're likely to be suffering that disadvantage for a much longer time. And to such an extent that it's not actually the same disadvantage, because losing pay and being off sick potentially for years is not the same thing as having it for a few months.
Okay, so let me ask you a cheeky follow-up, which hopefully illustrates the point. Do you think that the merits of the claim are different if the claimant has a back injury which completely resolves in 11 months? Okay, so that's claimant one, versus a claimant who has a back injury that resolves in 2 weeks.
Yeah.
claimant 2. Are those different claims?
Yeah. Well, you obviously, if you're acting for a respondent, you pick your arguments to suit the facts before you.
Yeah.
So if you had the 2-week back injury claimant, you'd say this is ridiculous and there's no way that this person is in reality suffering the same disadvantage as someone who has a back injury for more than a year and is disabled. But you'd have a much more difficult time making that argument with the 11 months person.
Right. So there's a sort of gradient, isn't there, which I
yeah.
think for disability particularly is rather difficult. Maybe it will be easier once we have some reported cases with real facts to sort of grapple with. But for now, it's going to be very fact sensitive, isn't it? As to whether a claimant can establish substantively the same disadvantage.
So Iris, what should employers be doing differently with Section 19A in mind, or do they need to be doing anything differently that they're not already doing for ordinary indirect discrimination?
Okay, so let's think about the way that employers currently tackle their litigation risks relating to indirect discrimination. I think probably most employers look at policies in general terms and assess whether there are significant group disadvantages to particular policies and assess whether those group disadvantages can be justified or whether actually tweaks could be made to those policies to lessen the disadvantage to groups with protected characteristics.
In a way that still meets the underlying business needs.
In a way that still meets the underlying business needs. So, for example, the need to have a particular shift pattern might be tweaked if there's actually a different shift pattern which is less difficult for women with young children to comply with, but still gives the business the flexibility that it needs for shift patterns.
In that example where they're thinking of the potential for a disparate impact, a particular disadvantage to women, does it make a difference if there's now the potential that a man could bring a claim because he has childcare issues?
I don't think so. I mean, except for the fact that there are more potential claimants. So previously, before Judge Eadie gave her decision in Rollet, before Section 19A was enacted, so let's say before 2024, an employer might say, okay, I've got these policies, they disadvantage women disproportionately because women tend to have childcaring responsibilities. The sorts of claims we're going to get if we mess this up are going to come from women. Now it's going to be the sorts of claims we're going to get are going to come from people with childcaring responsibilities, be they men or women. Does that really significantly change the assessment that the employer is doing? I don't think it really
Probably
does.
not.
They're going to look at group disadvantages. They're going to look at justification issues. So are there other ways of achieving the aims we want to achieve with this policy without so much disadvantaging women? Women with childcare responsibilities without disadvantaging people with childcare responsibilities.
So when you put it that way, as long as the employer's gone through that thinking exercise properly, they've covered themselves against either type of indirect claims in Section 19 or Section 19A.
And they simply may find that if they've done a bad job, they've got more potential claimants.
Including.
But the reality is the assessment of whether or not the policy is potentially indirectly discriminatory isn't going to be any difference, because what you're actually assessing is the disadvantage. And the whole point of Section 19A is it should be the same disadvantage, whether or not the particular claimant is in a protected group. I think that leaves one final question, and that
actually a question that has come in the Q&A. So it's a handy time to pick that up. Because the question asked, what's the section of legislation for the Grove type case of associative discrimination? And that's what we were going to touch on is, under the new Section 19A, can you bring this type of claim that they did in Follows and in Groves, where the claimant is linked or associated with a person who does have the protected characteristic, and they're relying on that link to say that they're a victim of indirect discrimination?
And both the disability cases where typically in disability cases where this comes up, the individual employee has a family member who is disabled rather than themselves being disabled. Okay, Stefan, so let's break that down. And we've got a couple of minutes to talk
Yeah.
about this. And in a sense, the answer is really simple, but let's get to it by chatting about
Yeah.
it. Where in section 19A, in the wording of the new section, does associative discrimination sit?
It's not there.
It's not there.
Mm.
There's nothing in section 19A that says the association between the claimant and the person with a protected characteristic should be X.
Yeah.
It's not there. And interestingly, some of the criticism in Groves and Follows from the respondents in those cases
Yeah.
were, hang on a minute, what is the extent of associative discrimination? What association?
Yeah.
How close or not close
Yeah.
does an association
Does it need-
need to be? How can you possibly define
Does it
that?
have to be a family member, or could it be your neighbour or your third cousin,
Or in Ches,
yeah,
the neighbourhood where you live.
Yeah.
Not people that you necessarily know at all, but who happen to be
living in the same
nearby
area?
to you.
Yeah.
And that's a sort of bad
So-
example in a way, because that's a services case, but it just goes to show how wide
So you can't
the
actually
association could be.
rely specifically on association, but if
No.
you go through the section 19 exercise, so is the employer applying a PCP to the two different groups? Well, they're applying the PCP to their own workers, but
Right.
they're not applying a PCP to relatives of those workers, because the relatives don't work for them.
Right.
So they're not saying to the disabled relative, family member, you have to come into work.
No.
They're saying this to their own workers. Now, that might disadvantage their own disabled workers who, let's say, they can't take public transport at certain times of day because of their disability.
Yeah. So you have to
with
turn up for work at 6 o'clock in the morning.
Yeah.
Might disadvantage disabled employees more than it does
Yeah.
non-disabled. Fine.
Yeah.
But the only, I think this is what you're coming to, I'm
Yeah.
talking over here, Stefan, apologies, is that section 19A only has a mechanism that relates to same disadvantage.
Yeah.
That's the only connection.
So does
Approved.
the carer of the disabled person who's not disabled themselves, do they have the same disadvantage as their disabled co-workers have in getting into work? Now,
Perhaps on the facts.
they might have the same problem traveling, but it might be because at that time of day, they need to be caring for their disabled family member and can't come in. But then is that
does
the
that
same?
matter?
Mm.
So park for the moment. Let's assume for the moment the disadvantage is the same.
Yeah.
Okay, so I can't get into work at that time of the morning. I can't use public transport at that time of the morning.
Mm.
Disabled employees of your company also have that same disadvantage. They can't use public transport at that time of the morning.
Yeah.
But my reason is completely different. My reason is that I have to be at home caring for my disabled child. Your reason is that you can't manage. Not the disabled employees' reason is that they can't manage public transport when it's very busy, when at rush hour. Now, the historic case law on indirect discrimination, right back to Aesop, the sort of leading case on the meaning and extent of indirect discrimination. In that, Baroness Hale, Lady Hale as she was, says the reason for the disadvantage is completely irrelevant.
Yeah.
As long as the individual who is the claimant, so we're talking about a classic Section 19 claim, so long as the individual who is the claimant has the same disadvantage as their group, it's no job of the tribunal to look into the reasons why that is the case.
Yeah, it doesn't matter.
It's a total irrelevance.
The causal mechanism for the group being put at disadvantage doesn't matter. You just need to show there is a disadvantage.
In reality, you often do explain it, but you don't have to explain it. So you could potentially have an associative discrimination claim in the sense that we mean it, i.e. a member of my family or somebody I care for has the protected characteristic. But the test is not the association.
Yeah.
The test is merely the qualification of the disadvantage. What is the disadvantage that I have?
And is it
as a person who cares for a disabled child? And does it happen to be the same as a disabled employee would have? The fact I've got a disabled child is actually completely incidental.
Yeah, and that could work because the legislation says that the PCP puts or would put the protected group at a disadvantage. So you don't necessarily need to show that these hypothetical disabled co-workers, and they could just be hypothetical, actually exist, or you don't actually have to point to a disabled co-worker who's suffering that problem of getting into work. You just need to show that if it was applied to a disabled co-worker with that disability, they would have that
They would
problem.
have the same
and
disadvantage.
And then you have that same disadvantage about getting into work.
So,
Yeah.
final point.
Yeah.
Let's say I'm guessing this is part of the questions. You've got the questions up in front of you, and I don't just at the moment. But let's say I'm a claimant. I've got a disabled child at home, but I can't establish the same disadvantage. So I can't win a Section 19A claim, but I do have a disabled child at home, and I am disadvantaged by certain policies of my employer because I have a disabled child at home. Is there any room in Section 19 or in the now enacted Section 19A to read in associative, what we used to call associative
There
discrimination?
isn't, because we're out of the European Union, we're out of the transition period, so there's no longer any obligation to read domestic legislation in the way that's compatible.
There's not only no obligation, I don't think the tribunal can,
they
as
can't,
a matter of law.
They can't refer to EU law to read into it. So they're just looking at what the Equality Act itself says, and when you read the Equality Act quite literally, there's, as you said, there's no concept of association by discrimination by association in either Section 19 or 19A. There is, as we talked about earlier, such a concept for direct discrimination, but it's quite clear
expressly
that Parliament's made that choice that
Yeah.
you can have direct discrimination by association, but not indirect.
Yeah. And I think I'd go further than that and say, if you're talking about non-mar leasing, non-European law interpretation, domestic UK interpretation, English law interpretation of statutes, I think you would say, well, Section 19 expressly states a protected characteristic of B. So that's expressly got to be their own protected characteristic. And then, to the extent there's any wiggle room, Parliament has chosen to enact Section 19A in a very particular way. And so this has already been tweaked by Parliament. Parliament has decided how and to what extent to expand the remit of Section 19. That's Section 19A. There isn't any room to argue that there's some other claim to be read into either of those sections, or Parliament would have enacted.
And if you think that there should be protection for, and a lot of people do think this, that there should be protection for people who are carers, then that's a choice that Parliament needs to make, whether, for example, it's by creating a new protected characteristic of people with caring responsibilities, or by doing what the claimant in Hainsworth was trying to do and amend the reasonable adjustments provision so that it also covers adjustments for people who are connected with a disabled person.
Parliament is sovereign. Parliament could enact Section, I'm not advocating this particularly, but could enact Section 19 capital B that says that if a family member of the worker is disabled, let's say they focus on disability, let's say the parliamentary draftsman focuses on disability, and there could be a provision that says that Section 19 and Section 19A for disabled, for the protected characteristic of disability, are to be read as including an individual for whom the worker cares. Has caring responsibilities, who is disabled.
That could be one way of doing it.
It could be expressly stated. So far, there's no hint of that happening. The way that the legislation has been enacted in Section 19 capital A is only by reference to the connection of same, or substantively the same disadvantage.
And I think we'll finish off with one other question that's come in, which was, is there any chance of a claimant finding it favourable to use Rollet, that's the EAT decision, over Section 19A, or is the substantively the same test common to both? I think the answer to that, Iris, tell me if you think I'm wrong, is that you don't really have a choice, because as we talked about earlier, Rollet interpreted the law as it was before the end of 2023, and Section 19A is now the law that applies after the end of 2023. So it comes down to, when did your facts and your claim arise?
I think, yes, in principle, I suppose you could say in a post 1st of January 2024 case, I make my claim based on Section 19 capital A as enacted as in force from the 1st of January 2024. And alternatively, I rely on Section 19 as interpreted by the Rollet case.
Yeah.
I think, but now I'm thinking this as we're talking, I think you're right. The problem with that is that that was a Marleasing interpretation of Section 19, which cannot any longer apply because we are now beyond 31st of December 2023, and the Marleasing principle of interpreting domestic law in compliance with EU law simply isn't a part of our law anymore. So I think you're right. I think that the interpretation of Section 19 in the Rollet judgment can only apply to facts arising before 1st of January 2024. And we're beyond that now. The reality, because of tribunal time limits, is that any case that a solicitor comes across from a new client is going to relate to facts that have arisen more recently and that will be caught by Section 19A only.
Yeah,
that's the answer.
And it's worth saying if you do come across a particular date problem, it's also, you might need to check, and I don't know the answer to this, you might need to check the Brexit transitional provisions and check, do they refer to, when they say that Marleasing and EU principles no longer apply, is that relating to facts that arise before the 1st January 2024, or is it relating to claims that are made before the 1st January? I don't actually know the answer.
And on that bombshell,
and on that,
I think we should probably
think about
stop.
That. Yeah.
Brilliant. Well, thank you for those questions. They were very interesting, and it really is an interesting area of law, particularly as we have the indulgence of having a chat about law that hasn't yet made its way through the tribunal system or the higher tribunals and courts, meaning that we can say whatever we like about it, which is great. Thank you everyone for attending this webinar. If we haven't answered any questions, or if you have any other questions that you haven't thought about yet and are just thinking about now, please do send them by email to events@42br.com. If you're watching this as a recording and you've got any questions, please email events@42br.com. As I said at the top, recording of this webinar is going to be available very shortly. Please do provide us feedback on it. We really appreciate any feedback that you have for us. And very importantly, the next session in this series is taking place on Tuesday, the 11th of February. Alex Lawson and Alexander Adamu are going to be discussing how to properly plead a schedule of loss. Very important. How to avoid some of the most common pitfalls and traps. Bear in mind that the law, as Stefan and I have discussed in this webinar, is the law as at 21st of January 2025. Please do register for Alex and Alex's webinar of the 11th of February using the links on the website. Thank you, everyone, and goodbye.
Thank you.
Thank you, everyone.